Hey, J-Bone Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester. The court DJ. It's time to dive into the case. To the case.
What is up, everybody? Welcome, welcome, welcome. Look who I've got here, the dream team. I am so excited about this. How you guys doing?
Good.
Fantastic.
Thanks for having us.
Wonderful.
You
I love
guys
your
ready?
intro.
Surrounded by women, Jay.
I know. I'm very lucky. My job today is to just kind of throw softballs and let you guys knock it out of the park here. But before we get into this crazy young thug case, this trial, and what specifically has been going down these last couple of weeks, I want to introduce everyone who doesn't know already who my amazing guests are. So let's start with Katie Bogenschutz. She spent 12 years as a prosecutor in Florida, 8 years in Broward County, then 4 years in Tallahassee in the Second Judicial Circuit, where she was designated to prosecute approximately 1/4 of the sex crimes that occurred in Leon County, as well as numerous homicides and attempted homicides. In 2021, she was recruited to join the Jansen and Davis criminal defense firm after spending her first 12 years as a prosecutor. Then we got Afi Patterson. She has extensive experience in criminal defense and entertainment law. She currently serves as a production attorney for the Emmy award-winning series Divorce Court and provides legal counsel to Dish Nation. In addition to her law practice, she owns Blue Door Organics, which we will share the link, a skincare brand that produces premium organic products. We're going to share all their links. Please follow everyone, Twitter, YouTube, all the things. And then, of course, we have Allie. Allie is a partner in the Allie Motta, partner at the Chicago Criminal Defense and Kane County family law firm of Motta and Motta LLC. She concentrates her practice in criminal defense with a focus on felony narcotics and conspiracy cases in both state and federal courts. She, of course, is the co-host of the podcast Defense Diaries and babysits me and Bob during the day while we live stream trials. Lately, she's been helping us out. She's awesome. We love her. So, guys, thank you so much for being here. I'm going to start this out to give you guys a little context and play a couple clips here from the trial, and then we're going to go from there. For folks who don't know, Little Woody, Kenneth Copeland, Little Woody is...
I'm going to let the dog in. Sorry.
That's okay. Okay, go ahead. So Little Woody is like a star witness for the state against Young Thug in this RICO case, which is basically they're trying to prove that Young Thug and his associates are like a gang and not just a music, brand and company and label. So Little Woody is their star witness. They call him to the stand, and let me just share here. This is what happens when they call Little Woody to the stand to testify. This is the first day when he testifies. This is what happens. And if you guys, this, by the way, if you ever don't want to tell someone your age, if someone wants to know your age, this is the way to go.
All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Well, are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please?
All right. So after that, guys,
And I was wondering, I'm like, has he ever lied to the police about his age? Maybe that's what prompted the fifth so soon.
Well, before that
I
started,
would say that, like, if it was a sex offense and he's over a certain age, that maybe that, but it's insane.
I think he just didn't want to be there.
Yeah.
Yes,
Right,
very
right.
much so. And there was a lot of, like, before he even came on, people were like, I heard he's not going to testify. Apparently, the rumblings outside the court where they're like, the attorney's like, he is not going to testify. So that was on a Friday, folks. What happens then? The judge holds him in contempt, sends him in jail for the weekend, and is like, you're going to think about this for the weekend. And then he comes back on Monday and he starts to testify. But apparently, there is an ex parte meeting which is like a meeting. We'll get into it, but a meeting with him, prosecutor, judge, but not everyone. Not everyone was aware about it. And then Brian Steele, Young Thug's attorney, finds out about it, and he's like, "This is a major problem." And I'm just going to play this clip, and then we're going to get into it. When Brian Steele tells the judge, like,
go ahead.
"I know about this meeting."
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason...
Well, I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow what accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you, Mr. Adams, meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not
How
going
did
to
you
answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who the.
I'm not,
Tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't
who
have
it
to.
is, if you don't tell me who it is, I'm going to put you.
Well,
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege.
There you go.
I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
That's my favorite part. I'll take my notes. No. And just real quick to give you guys, if you didn't see what happens
You
next
all are
after
real.
5
You
minutes.
all are real. You're just glossing over it. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
They take him into custody. I mean, all right. So that's guys. Can you believe what you just? Alfie, starting with you. What were you thinking when you see this? What are you thinking?
It was, well, first of all, I was, again, as I refer to him as the good brother Steele, I think he did exactly what any other criminal defense attorney would have done. He did exactly what I would have done. I'm not going to tell you that information. Just my knee-jerk reaction, you're not going to get that information from me. It's between me and my client how I got that information. And I think that, unfortunately, one could argue that the judge was reacting just purely on emotion. I think that he felt like the sanctity of his chambers had been violated, and he just didn't like that. But what was really interesting was after I think Brian Steele was cuffed, his co-counsel went up to the podium and said, "Hey, just so you know, I got the same information that Steele got. And I believe the same thing. I'm not revealing that information either." And the judge said, well, I asked Steele. I didn't ask you." I was like, how about some equal, dishing out of your ruling? Where's the equity in that? But those are my initial thoughts on that.
And I guess Allie, what do you? And the one thing he doesn't say, that didn't happen. No, I don't know what you're talking about. He's more like, who told you? It was like a mafia thing.
Yeah.
Who's the rat? Who? So
let's talk about the substance, like not the source, but the substance of what actually happened. He wasn't even worried about that. It was just worried about the source. And again, I think he was sensitive about his chambers being violated, what happened in the chambers. So.
Right. And Allie, I know you saw this and you went down a deep rabbit hole. What were you thinking when you see this?
Well, I mean, it gets even worse because the other attorney also says, because he holds him in contempt and he intends to not have him be at trial, to have him be in jail. And the other lawyer is like, well, I'm not proceeding without my co-counsel. And the judge is like, I'm sorry, sir. That's not how this works. You don't get to extort me. He's in jail. You're going to proceed. And the other lawyer's like, I am not going to do it. I am not going to do it. You're going to do it. I am not going to do it. And finally, the prosecution's like, Your Honor, considering his right to his counsel of choice, I think that what you should do is hold him in contempt on the not in session hours. And then the judge is like, oh, okay, yeah, I'll do that. But I mean, it was just like, it was outrageous that they were both like promising each other. Like at some point, it's like, well, once you tell me who told you, then I'll answer your questions. Well, once you answer my questions, I'm going to tell you who told me. And neither of them intended to follow through, with that promise at all. And I have never, ever, 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 ever had the prosecution have a private conversation, ex parte conversation with the judge. Even if a lawyer is like, I've got this going on, oh, the judge is on, there's a trial in the courtroom. Do you care if I have an ex parte communication with the judge for scheduling? Like they'll even ask me that. And the only time I have ex parte conversations with the judge is after I have presented a motion that I need to speak to you ex parte. And that has only ever been about trying to get funds for an indigent client who needs an expert so that the state, so I'm so used to read now, everybody's the Commonwealth. So the government or the state does not know why I am asking for it. And universally in state court, they say no. And I'm like, what is wrong with you people? That's the way this works. In federal court, the statute specifically says that the defense counsel can ask ex parte for that information. Shy of that, I can't imagine any reason, unless you're like in a federal court and they need to have some sort of ex parte communication. I don't know, like national security, some sort of security issue, but they're going to tell you first, we need to have a communication. This is what it's going to be about. You're not invited. Like him being like, there's nothing, this is fine. We do this. I'm like, what? And so I looked up the statute to make sure I wasn't out of my mind. And it's the same as every other statute, no ex parte communications whatsoever, especially when the guy is on the stand. Now, if the lawyer for the witness was telling the state, or someone told the state, this lawyer was hired by the defendants, I don't think he's my lawyer. I don't think he's helping me. And I am fearful for my life. I need to talk to the judge. If the witness is asking for that, then maybe in some world I can see, but I think they would still need to tell the defense that that this is going on. That would be like a super unusual kind of situation. But it doesn't seem like that's at all what happened here. So it's very improper as far as I can see.
Katie, what were you thinking? I know we were talking. There was
prosecutor. So let's hear. Katie's got a.
Yeah, Katie. What?
It is. I wasn't even watching this trial, and my husband, who is also a former prosecutor, is the one that sent it to me with like every emoji he could find of like a head exploding. And he's the one that got me really riled up about it. So I haven't watched the rest of the trial, but I remember watching it and going, it's like mommy and daddy are fighting and I'm really enjoying this because I'm not there. But if I was a member of that prosecution team, I would be peeing my pants. This case is going to end up coming back. It's an 18-month trial. You're mistrying it right now. And I understand there's been a ton of other reasons to mistry it. But like, it's coming back, man. And like, this is not a clean trial. And so for those of you who are watching, ex parte is usually a dirty word. Like it's ex parte means you're excluding the other party to the case. And nobody should have conversations with the judge like that when a jury has been sworn and you are mid-trial.
And the witness was already testifying.
And the witness was already testifying and was sworn in. Like, this is not a game. And I can't come up with the scenario where this would have been appropriate. Sorry, I have lights there we go.
Best case scenario though, do you think that, this would have not gone the way it did if the judge provided the transcript right away?
I'm sorry, I lost the end of that.
If the judge provided the transcripts right away to all defense counsels.
Well, also let them know.
We'll let them know beforehand. But I mean, if there was some kind of emergent life and death reason that this occurred that I can't manufacture in my head right now, usually ex parte is allowed for scheduling purposes, administrative purposes, and other kinds of emergencies like, hey, judge, my co-counsel just had a heart attack. I'm driving him to the hospital. Those kinds of things. And, please tell opposing counsel. But I can't. And from what I have heard, because things have leaked, obviously, but from what I have heard, that there were like some substantive admissions made back in chambers. So at what point does this also become Brady?
Yeah.
Discovery. And you're having them continue with this trial without going through it. And for those of you who are unfamiliar with Brady, Brady is also a dirty word for prosecutors anyway. It means that you're aware of exculpatory or impeaching information for this witness. So if this witness admitted to doing stuff behind closed doors, and I have a transcript of it as the prosecutor, you have to turn that over. In fact, you should just turn everything over, and then you can argue about what's admissible later. This is like, they've just wasted so much money on this trial. It is coming back.
And Jay, I don't know if you planned on talking about the motions or not.
Yeah, I want to get into all of it.
Ahead. All right. Do you want to?
Yeah. Well, sorry, I was gonna ask Afi. Like basically at the end there, right? He says Kenneth Copeland said he admitted to a murder, right? Like he's talking about stuff that none of these. If you guys don't know, this is a RICO case, so there are several defendants, several attorneys, and none of them are part of this. And it sounded like a shakedown. They're like, listen, dude, you're gonna start talking, right? I mean, Afi, is this like what Kay just said? There's stuff that's coming out in that meeting that none of them are aware of, and then he's like, he doesn't care that like that happened. He's more pissed like who let this out, and he's not giving out the transcript. He's not doing anything. Like what is going on, Afi?
Sorry. So yeah, like Katie said, this is massive because it's a huge Brady issue. Like that's the you know you can't pass go at this point. I think you have to address this. And I don't know if you guys saw, and I don't know if Katie, if you know, but I think Steele said that he amended his witness list and he made the state, the district attorneys witnesses, and he's also going to call the judge as a witness. You know, and this is so that's going to be
yeah. Don't give me the transcript, and guess what? Y'all can testify to it.
I mean, they denied his motion in the first, so he's not getting a chance to do any of that. The judge.
Well, that's what I wanted to ask you guys about. It's like he doesn't. He's just like motion denied. And when Steele's attorneys come in, they're like, "You can't handle this. You're going to be a witness in this." But he's just denying it. Like, have you ever seen something where the judge is just like, "Nope." He's not even like entertaining. And now it seems like he put it off for like because they're not having court until like July 8th or something like that because they have like, but that he's going to somehow handle the motion regarding this meeting. How can he handle that?
What, procedurally, Alec, do you know what happened procedurally with the witness situation with him subpoenaing the judge? Like he just summarily denied it.
Yeah, so they filed a motion for recusal for that judge to have to recuse himself, and they wanted to bring out factual evidence about what occurred. Now, one of the biggest things to me that came out of that, one of the more shocking admissions, and there were two of them, but there's only one that's staying in my mind because it was so bad, was the allegation by one of the defense attorneys that the prosecutor told Woody, if you lie, I am not going to prosecute you. That is, I mean, like, talk about Brady. If she said that in front of the judge, that is the most outrageous thing I have ever heard. And if there is a possibility that that was said, this is going to be a huge issue. But so what I do know that happened is the judge denied. So here's how it works there. You go in front of the judge, you present your motion to recuse. He looks at the statute. 3 things have to be established. 1, timeliness. 2, like that the form of the motion is correct. There's an affidavit, it's sworn correct. And then if I accept everything you say as true, have you established that recusal would be appropriate? If so, it goes to another judge to hear the matter. So that's where they're saying you're going to be a witness, they're going to be a witness, or that you know, they're hoping to call those people as witnesses, I guess, to kind of collaterally impeach Woody, which doesn't seem necessary by any stretch of the imagination. But since the judge denied the motion, he's not going to be a witness because they're not getting heard. And then the Supreme Court took the contempt part of this. So the contempt part, there's criminal contempt, there's civil contempt, there's indirect contempt, there's direct contempt. If you are violating a judge's order, that is direct contempt. It's happening in front of the judge in the courtroom. He's seeing it with his own eyes, direct contempt. But the judge was confused between criminal and civil because civil is, I'm going to keep you in jail until you do what I say. Criminal is, you have now been punished. So the judge decided, okay, this is criminal, so I'm going to give him 20 days up to 20 days in jail, which is what the statute allows for. He filed an appeal. The Supreme Court took it, granted certiorari. So it's like the Supreme Court is already considering that issue. But I do think technically the Supreme Court could say the judge gave you an order, right or wrong, good or bad. Judge gives you an order, you didn't listen. That's contempt. They may also take issue with what the judge did as well. But technically, when a judge's order is wrong, we still have to file. It's not like we have the ability to be like, well, that's wrong, and not follow it anymore. So, I mean, that's my understanding of procedurally where we stand. And then Woody got back on and, continued to testify. And I don't know if any more has happened over the past couple of days. Last I heard it was, I'm going to go through the transcript. I'm going to decide what might be Brady, what's discoverable, and I'm going to give you a redacted transcript. And they're like, what? No, you're not. Now, I think if he thinks there's grounds to redact the transcript, he should be giving it to another judge to decide what needs to be redacted, because then the only people deciding are the judge and the state, who also saw no issue with this and, wasn't going to tell the defense either. It seems like no one was going to tell the defense. So, and I don't know, I might have just went full, all weird from Afi's question. I'm not sure if I.
No, thank you. So I understand you talked about the motion to recuse and the contempt issue, but I'm talking about the actual trial. Steele said he's going to call the judge and he's going to call the DAs in the actual trial. Like, I think that's good. That they haven't addressed that issue yet. Like, I don't know if he sent subpoenas to the DAs yet, if he sent a subpoena to the judge yet. But also, like, what takes precedence, like your duty to your client or your judge's order? Like, can a judge order you when you have, again, national TV? Can your judge order you to violate that attorney-client privilege? Do you have to,
No, you don't have to. I've got to revisit this, but I don't believe you have to. If it's attorney-client privilege, you cannot tell the judge if he's like, "What did your client say to you?" But no. But the question is who told him this information attorney work product? And I don't know. Being intellectually honest, the person who gave him that information might not be attorney work product.
What do you think, Katie?
Well, if you want to say that the person who gave him the information is potentially a witness in the case, and it's his conversation with a witness in the case about their testimony, then maybe you could try to torture that into attorney work product. That was my thought process. I'm also kind of thinking to myself, like, clearly this judge is not going to back down. I think we're all on page with this, that he is going to drive this train right over the cliff. But my question for the defense team, and if they're watching, feel free to take this idea and run with it. You need to ask to proffer the information that they would testify to the court and to a court reporter, so that there is a really good record as to what happened in that meeting for the Georgia Supreme Court to look at later. I mean, this is like, have the prosecutors all testify to what happened and how they decided to have the meeting without the defense, and the judge have him testify to all that, why the meeting was held without the defense. And then he put the entire transcript in evidence as well as an exhibit, not an exhibit that goes back to the jury, a court exhibit, so that it goes up on appeal with the case for the 11 billion reasons this is going to be appealed, if there's even a conviction.
Who would have to approve that? Like, because he's not going to prove that, right? The judge. Who would if they suggested that, who would have to prove that?
Well, it would be the judge, but she's right. If
the judge, I'm asking
is saying, I'm not letting you call these witnesses, then the remedy is a proffer, which is what the witnesses would say. But
I want to swear in you three prosecutors and you, judge.
Technically, he should have to do it, but I don't know that he would. There's going to be definitely a statute for the judge as to when you're allowed to do it and when you're not. And I'm not sure what that is, because I have never had to even contemplate the possibility of calling the judge as a witness in a trial. It is an absurd proposition. And I wonder if he could even, avoid proffer under the rules, but I think that the prosecutor, I don't see how they would avoid a proffer. And not to
file a
get
protective order and
right, and not to get wholly off track, but the first time I heard anything about the case going on was my daughter saying, or it might have been one of my kids, like, can a judge use lyrics from a rapper as evidence? And I'm like, absolutely not. Don't be
Yeah, you can.
absurd. Well, here we are. I mean, it's the most ridiculous thing that I've ever heard of. People are not saying things that are true. Maybe they are, but it's artistic privilege, so you don't know that it's true, and it's, I think, just absurd. But
Funny,
yeah,
because that also came up in YNW Melly. They wanted to use it, but I don't think it was allowed in YNW Melly.
but it was allowed here, right?
If I remember correctly. Yeah, and I think it is allowed in this one. And Afi, I mean, you've been following this. First of all, the thing with Little Woody is when he did testify, he basically got up and was like, "Listen, I just lied. I just lied to say." And Afi, this is basically, correct me if I'm wrong, one of the state's major star witnesses is supposed to put Young Thug in jail, which, by the way, Young Thug's been in jail for forever. This is insane how long he's been in jail for to have this man come up and be like, I just lied about everything. What did you think? Like, what, separate from what's been going on, what have you thought about what you've seen of his testimony?
So, okay, this ties into a comment that I wanted to mention about the jury and how, I think they're losing their jury if the jury hasn't been lost already. Because I think we're on some type of break until you mentioned like July. I kind of watched a little bit today about the scheduling. But it's, the jurors are going to think, this is another waste of my time. He's basically saying, and that everything he said to the officers has been to basically get the officers off his back, to, get them to leave him alone so he can go home. And he's going to be either supported or eviscerated, what have you, on cross. But it's like, nobody is going to believe what he says. So it's like you're wasting the jurors' time. And there's a big issue in this case because they've taken so many breaks already, and they've taken a lot of the administrative days. So the issues have been, you guys said it's going to be a very long trial. It's been a long trial already. But the issue is, they're not getting paid. They already get like a very small stipend when they're actually observing and serving as jurors. But on these administrative days, do they get paid? On these half days, do they get paid? And it's already just such a small amount already. You're going to, your jurors are going to turn on you no matter if the state proves guilt or not. So that's, a huge issue.
Absolutely. And so, Allie, if you're talking, you're muted.
Oh, do they have a bunch of unemployed jurors?
Yeah.
I don't think so. I think it's some people that are on like day 95. Can you imagine 90? I think it's 95 days or 6, being at a trial, not being able to work your job, not being able to live your, like, I don't know. I can't even imagine.
This big gap. I feel like, how obviously jurors aren't supposed to ever talk to anyone about the case. And I mean, this is so long of their lives. And then you get these like long gaps. I feel like there's probably a damn good chance that these, jurors are having some conversation or something's happened. It's just too long and too much. And if they're getting, I don't know. Do you guys know how many alternates they have? Because this is
that I'm not sure.
And it's possibly even unavoidable. I mean, could you really, in Atlanta for this long of a period of time, like the longer a trial goes, the more likely somebody's going to do something dumb. And it's probably going to be one of the jurors.
Or the judge who had a meeting with.
Well,
so let me ask you this, Katie.
Enough of them to go around.
we talked about this before we came on, but I was like, so how is this going to get resolved? Could this judge possibly get removed? And you were like, yeah, anyone but pretty much the defendant and the jury can be. So can you see a option where Judge Glanville is no longer, after all this, is not that they bring in a new judge? What do you think, Katie?
So the judges are allowed to talk amongst themselves, and it would not shock me if maybe the chief judge doesn't call him in, like, dude, what do you want to do with this? And have a a little closed door chat about it, which I know does happen quite frequently with chief judges. And I mean, you're essentially giving the defense a free trial. I mean,
I
if,
wonder if the
if
Supreme
there's a
Court,
conviction, it's going away.
Look, Grant
the
Hill is
Supreme
the
Court
chief
could-
judge.
Oh, he is?
Can I insert that for a second?
Of course
He's
you
the
can.
chief judge.
he is the chief judge.
Yeah.
So
Oh,
do we
boy.
think the Supreme Court could declare a mistrial? I just want to say, if a mistrial is declared, my understanding, and either of you and Katie, tell me if I'm wrong, this would fall on the state and double jeopardy would apply. There cannot be a mistrial and a retrial if this is the reason for a mistrial, as I see it, unless I'm missing something.
So you're referring to whether you are goading a mistrial by doing this?
No,
By
whether
instigating this,
if
or
it's
just like by committing prosecutorial misconduct by doing
right,
a-
if it warrants a
an
mistrial. Now,
expletive.
here's the reason I don't think it warrants a mistrial, because I think it's kind of harmless error because of what we just said about how Woody has testified. It's like, okay, none of this really matters because he hasn't said anything that's harmful. I haven't watched all of it, so I don't know if he has said something harmful to the
But it's
defense.
curable too. Just give them the transcript.
Right, it's
they're
curable.
not
They
doing.
give them the transcript and they let him know, and that's what when you say judges are allowed to talk, I wonder. But he's the opposite.
I know.
Well, maybe all the other judges come to him and say, "Hey, Chief Judgey, what you're doing is wrong. You better give him the entire transcript, or allow me to suggest you let a panel of other judges decide what should, be going in." But I wonder if the Supreme Court, although taking a contempt petition, could decide sua sponte to take up some of the bigger issues here. But
Would they do that?
Depends how serious, I guess, right? I mean, what do you guys think? Could they do it?
I think they could do what they want to do, but I don't think they'll do that.
They could also address it as dicta. They could try to say, this isn't in front of us. However, here's how we really feel about it, and here's what we would do if it went up on appeal.
A little bit of guidance, a little bit of gentle guidance.
Right.
Yeah, and maybe in black and white that says, "Judge, you better
give them the damn transcript."
Right, and I've heard of judges and prosecutors being called as witnesses, but not during the trial. Like, I mean, usually it comes up afterward, like, oh, something happened. We better get this on the record. This is during the trial.
So this happened in the YNW Melly case when it was a huge Brady issue, because the prosecutor, I forgot what happened, but the prosecutor,
I remember.
Information, she didn't turn it over, and the defense was like, we're going to call the prosecutor. They actually wanted to recuse the whole office and bring in a special prosecutor. It was a huge issue. So I mean, and we all saw that happen. That was wild. So I was like, it's happening here. And then someone said the other day that it was happening in the Karen Reed trial as well. So,
well, YNW Melly, it did not. That whole thing, there was a mistrial, and then they were coming back for motions to retry him. And that's when the defense found out about it. This is mid-trial. Like,
yeah,
it is wild.
And by the way, for folks, I just found out talking to Katie before we started that Katie worked with some of the folks in YNW Melly, so we might have to have a separate.
Yeah, all of them. I was down there for a long time.
What side?
Huh?
The defense or the state?
I mean, I so the only one I don't know is Mr. Howard.
She knows Stu. She knows Christine. Who else was in there?
I know Christine. I know Stephen Klinger. I know Port Taylor that picked up the case, and Alex that picked up the case. The shit sandwich that is now sitting on their desks.
And the judge. You're familiar with the judge?
I know the judge, but he wasn't in felony when I was in there.
Howard was my evidence guru. I think what's Howard?
Where is he from? He's not from He's not from Fort Lauderdale.
He was the evidence guru. He was.
Katie, you're in Broward?
I was.
Oh, I'm like spacing on that because I've got a case in Broward, a federal case right now. Maybe did you do any federal work?
Yeah, sometimes. I moonlight.
Maybe I'll have to pick your brain.
Yeah.
All that I've left is sentencing at this point, but it's a drug trafficking case, and but I'll have to see if you know our judge, and
I'll message you on Twitter. Give me my number.
okay.
Well, getting back to the young thug.
Yeah, we're networking now.
Right.
Let me ask you guys, like, if you had a guess on whatever you want to go, how do you think this is going to get resolved? Like, he's the chief judge now. Afi has told us this is the chief judge, the boss of the judges. How is this possibly going to get resolved?
He's made it clear. I'm done. Go F yourselves, and we'll see what they say about this on appeal. That's him being like,
when you say on a, so that means just, you mean not appeal of the contempt here. You're talking about the entire trial.
Yeah.
Yes.
So you mean somebody's even convicted after
He's like swinging his giant thing around, throwing it on the table, and saying, "Take that and show it to the appellate court, and let's see what happens."
And nothing could stop that from happening, basically.
No.
Wow.
And I mean, if I'm the state, I'm like, you're giving the defense a free trial, man. Like, this is their free trial. If they get if the defendants are acquitted, there is no retrying. Jeopardy has attached. If they are convicted, then the chances of this getting reversed are, I mean, just from what I've seen, and that's not even the full 18 months of what I assume is probably massive errors based on what we've seen previously.
For example, allowing a witness to continue testifying after he tells the judge, the court, that he's falling asleep because he is so high. Get this man a bottle of water and let's keep moving.
Yeah, that's which is exact. That's not. She's not joking, folks. If you missed it, Little Woody said, "I am high."
No, it was different witness like 2 months ago.
No, that was Little Woody.
Was that Little Woody?
I'm pretty sure because I just posted the clip. He said, "Yeah, he said, I am high. I'm high as fuck. I think I'm about to fall asleep on y'all." And they got him a glass of water, and it wasn't like, no, we can't.
I think two people must have said that because I didn't think it was Woody.
Oh, maybe then I'm wrong. I thought I posted it today, and it was.
It may have been.
Maybe you're having a hard time telling. He had a face mask on, right?
Did have a mask on.
So that's not Woody, unless
it's not Woody.
Jay.
I'm looking at it right now. Wow, I got it wrong. I thought it was him.
Don't put drugs on Woody.
I know.
He did have a mask on. My bad. He's been a character. Anyway, to your point, any witness that it's probably not good if they're saying that they're high and
they're not. Sorry, we're gonna have to continue this, and you're gonna have to come back another day.
So, all right, so my bad. I don't know why. Why is it just coming up now? That clip I just saw for the first time. So Afi, what do you think? They're just gonna go forward for how long? Do you think they have left? Literally, like, do we have another? If they go forward with the trial and there's not, like, nothing happens with this, are we talking about another 9 months to a year of this trial?
I hope not. I didn't even have the words. Okay, if we can start from the beginning. I don't know if you guys, like Allie, Katie, if you guys know, but there was like a 400-person witness list, and I'm just thinking, do you need 400 people? For this RICO case? I know, RICO cases are normally huge, and but in this situation, you don't need 400 witnesses. And then eventually, a few months ago, the judge had them cut it down to 200 people. So I think, even with 200 people, yeah, it could go on for another 9 months. But do you need 200 witnesses? At what point does it become just cumulative, and unnecessary?
I'm so glad you brought that up.
Yeah.
So how many defendants are they trying at the same time? It's like, I know it's like a 26-person indictment, right?
Yeah, but they dismissed a bunch of people, and I don't know if they dismissed just from severed. Maybe is that Afi more appropriate, severed as opposed to dismissed, or do people plead out? Do you know?
They pled out. Yeah,
okay.
They pled out. So I think it's between 6 and 8 now. I don't know. And then Miss D. Williams, who I love so much, like, why is my client here? Like, he's in custody for life.
Yeah.
He's a kid. Why are we even here?
Little Rod, right?
Yeah, that's been her argument to the jury. Like, this is a waste of your time.
You know how many?
Like, yeah.
I mean, how many do you think, Afi, of like record labels, if they're taking the individual crimes of the people associated with a record label and trying to say that they're a gang? I mean, I haven't watched all of this, so I did hear some testimony of the co-founder that it started as a group and somehow at some point it evolved into a gang. Now, that was something he was made to swear to in an affidavit as part of his plea agreement. I don't even think it's true, but I don't know. And I know at some point he kind of seems to say, like, we were pretending to be part of the Bloods, you know, but we weren't really Bloods, but we are Bloods. So I didn't really get that.
Yeah, we testified. No, there. When I first started as a public defender, I remember, talking with some prosecutors, and they were talking about gangs, and I was like, oh, I know that neighborhood. And basically they were saying that, these young boys are a part of the gang because they have like the same line in their hair, like when they go to the barbershop, or they wear like certain colors, like, you do that when you come from certain neighborhoods, my neighborhood, very nice neighborhood, we do certain things, like we're all friends. We all go to school together. Like, you can't say that we're a part of a gang. So I guess their definition is very, very loose of what a gang is. You live on a particular street, you live in a particular complex, you must be part of a gang. And that's what they're banking on with this RICO charge. But the defense is arguing these are people, living their lives. They may stick up some people, they may burglarize a home, they may thieve, but it's like they're doing that independently.
Individually,
it's not, they're not a member of a gang.
I mean, are the Heathers a gang? When you get a group of white people or girls together, so growing up, I grew up in a town in South Jersey where there were a group of boys just started calling themselves the Playboys. Okay. And they wanted to be like a gang. And when was the strangest thing, because in one of my early college classes, and they talked about the local gangs, they said the Playboys. And I was like, oh my God, I know those guys. And that is just a group of people who are calling themselves. It's like me and my friends, we're the Babysitters Club. So, we're the Heathers. It's like, and I have that issue in one of the bigger towns, I'm talking outside of Chicago, where they just say this person's in a gang, he's hanging around a gang, he's wearing red, he's got it, just like she's saying. And then they are forever, like the law is starting to change on that because they see how people are labeled a member of a gang by the police when they're 12. And then when they're 40 and they get in trouble or they have a gun, it's a known gang member with a firearm. And, they up all the penalties. And when you grow up in parts of Chicago, and I'm sure parts of Atlanta, your friends are going to be affiliated with a gang. You can't hang out with a group of kids where someone, whether it's official or not official, is, throwing up signs as though they're in a gang, or they feel affiliated with the gang, or they're from a certain neighborhood. I mean, you got to walk around like with your head in the sand to not affiliate with a known or suspected gang member. And that, for people of color, brown, black, it is
white. Sorry.
Well, it's just a way for the government, the system, to over penalize people of color, and not not even just recognize that the environment when you're a child and what you say and what you do, that is not you like forever. Like that is just, and it's still going. And for them to call these men who have evolved from when they were 15, 18, 20 into actual adult human beings that may be committing crimes independently, but try to group them together and call them a gang because when they were in their early 20s and teenagers, they like to call themselves YSL and they wanted to throw up, hand signs and act like that is like real and legit and just follows them through life forever. The people are like, well, that's when I was a kid. Like I'm an adult now. you know, like, so it angers the fuck out of me. And I don't even know why I'm talking about it. I'm sure Afi is much better to from the area and know, like you said, that you've seen them just call people a gang from things in their hair, like from the other side of it.
I'm not from the area or the neighborhood.
No, I'm saying that you've seen them in the prosecution office or whoever's office say if they've got a certain hairstyle, they're a gang. If they're wearing, you know, like just arbitrarily label people as a gang.
I'm saying that if you live in the same neighborhood and your friends are in the same neighborhood, you guys go to the same school and you guys hang out at the same arcade on the weekends or the skating.
There's like a microculture there.
You're going to say, like, it starts in elementary school. Like, I remember, you know, my friends and I would all wear our hair braided and we'd wear, you know, the same color ribbons at the end and we'd have a name. Like, you know, but what I'm saying is they'll use anything to call that group a gang. And what's so funny, and I think what's going to be detrimental in their case is Woody said he was a blood and then he wasn't a blood or something like that. I don't know if you guys caught that. If you think about like what an average person knows about a gang and you know, the largest gangs we can think of are like Bloods and Crips. You can't just be a part of them and then like not be. You know, there's a formal procedure for getting in and getting out.
Jumping in and getting jumped in and getting jumped out.
Yeah. So it's
like a sorority where you didn't pay your dues that year and you're going inactive.
So it's kind of laughable for them to say, oh, you know, they keep trying to associate them with the Bloods. But if Woody is saying, yeah, I was a Blood or I was affiliated with him, but now I'm not, like, you know, it's just laughable. Like this isn't really legit. You guys are pulling that like really, really fine hairs to call them a gang.
And well, Afi, where were you saying that you were working where they were talking about it and then trying to say like they got a certain line in their other?
Yeah, East Baton Rouge Parish.
But was that in a prosecutor's office or at a police department?
No, I was a public defender, but you know, you work closely with the defense counsels and all the prosecutors. You know, you go to school with people, you go out and you hang out. You know,
I mean, to your point, some of the things that they're trying to relate them to being gang is like an Instagram picture where they might be. It's ridiculous. Like, whoa, and that's what a lot of what they're having. Little Woody and other witnesses point out, like, is that tattoo that is he putting up the sign here? And I mean, we saw it in the Melly trial too, where they were like, they had the whole pamphlet and they had like the whole thing you had to do. It seems a little ridiculous to me. But let me ask you this, Katie. So if you're on the prosecution team, and you know, right, you're like you're saying right now, like this is going to.
I'd be mildly suicidal.
Yeah.
Like, what would you try to do? Like, if you like you said, this is done. This isn't. If this whatever happens, this doesn't matter, right? That's what you're thinking. If you're on the like, how do you remedy it? Can you?
From what I've seen, and the thing is that I can't imagine. Like, it sounds like all three of them were there, right, in the meeting, and not one of them said, oh, I don't know about this, you guys. Maybe we ought to tell the defense about it. Like, who the hell are these people? We're like, I'm not going to run this past somebody else up the chain in the office. I'm not going to, you know, double check with my professional responsibility people. Like, I mean, I spend a lot of time based on like some of the stuff that my clients pull now in criminal defense. I spend a lot of time in the past month in particular on the Florida bar ethics. They've got lawyers there that you can talk to, and nobody thought to like call into that and say, I got an issue. Can you help me out here? Here's the scenario. And I can't imagine that there's nobody with brakes on that team. Like there's nobody tapping the brakes. We're like, oh, okay, we'll just go back here with the witness and the judge. And the witness is sworn in. And
I think they felt, two things, right? Number one, I think they felt emboldened because of the calls that the judge has been making with, you know, and he's sided with the DAs, right? So that's number one. But number two, is it up to them or is it up to the judge? I can request an ex parte meeting all I want. The judge can say, this is improper. No, why can't the defense be here? So who's it really on? Because, you know, as attorneys, you're going to take all the liberties, you know, you can, and it's up to the other side or somebody to stop you.
But you have a different ethical obligation as a prosecutor. Your job as a prosecutor is not to seek a conviction at all costs. Your job is to be a minister of justice. And if justice means you dismiss a case or you null pros it, then that's what you do. And I just can't imagine that there weren't like cooler heads brought into this meeting. Like I would have been emailing people under the table going, hey guys, they're trying to lure me into this back room. Defense isn't invited. I don't feel good. Somebody come save me. Somebody with more gray hair than me, please.
The old gray heads. The old gray heads.
No, but like, you know, somebody's
know.
like, I'm 15 years in now. It's like somebody with like maybe 30 years, come get me.
And Afi, do you know, so right now, how many days have they not been in session? Like since the day that the judge denied the motion to recuse and said, I'm going to get you the transcript before cross, I'm going to redact it. What's happened since then, or has anything happened since then?
They've had, I don't know. They've had like maybe 2 days of some half testimony, maybe 3 days. But what I can tell you is since the, what is it called? A supersedis bond? Supersedis bond. Since he was granted that bond, the judge has been a little nicer. He's been talking soft.
Yeah,
I heard someone commented that.
He hasn't been as spicy. You know, there's a little bit of oversight now, especially since everybody across the nation is talking about it. But yeah, so, and it's only day, 90 something of the trial. But how long have they actually, the trial's been in session? It's way longer because they've had so many breaks.
Yeah, that's one of the reasons I started covering it. And then it was like a break, like, and then they would come in late, like 2 hours. Like it's their schedule is like, I just can't imagine being a juror. Not only can I not imagine being a juror, what about a public defender? Who, I forget who you were saying, like a person who's not getting paid a lot, and that's like one of the attorneys who has to be there. Didn't one of the attorneys say, Lil Rod's attorney was like, I gotta get out of here. Like, how can you, like, if you're not like how could you do that if that's your job and you're just doing this and you can't do anything else?
I mean, you're
like,
still getting paid. You're the public defender. I'd be like, this is nice for me. I only worry about one thing.
Allie, it would be great if you're a young attorney to cut your teeth on a trial like that. That would be fantastic. But I think Lil Rod's attorney I think she's like conflict counsel.
So she's private.
Yeah, so she literally can't make any other money, and they're only paying her probably, I think it's like between 45 and 47 a year. What is she going to do with that? She can't do anything. When you take on murder, RICO, you know, things in that echelon, you can't do anything else. You've got to shut down your office. She can't do anything, and she's only making, under 50,000. That's absurd.
So when Afi says conflict counsel, so when the public defender's office is conflicted out, for example, they represent, one person, or they have represented one person, what the courts do is they go to private attorneys like they did in the Richard Allen case. Those are private attorneys who are appointed, so they are paid. So what Afi's saying is this lawyer can't take any other business. So she's literally being paid. And sometimes we're like in federal court, you're obligated to be on the roll of pro bono counsel. So if your number comes up, you got to take it. So now this lawyer, I mean, like literally it sounds like it could be devastating to her family, to her practice, to everything.
And her client already has life. Like it doesn't matter. Like and it's crazy.
Are there other conflict counsel on as the defense? Afi, is that the only one?
I don't know. I don't know, but I do feel sorry for her.
I'll tell you, my firm opted out of that for I assume that reason. Like we will not take those, and we're lucky enough to be able to say no to them. But it's because it will ruin your life.
Right. If you're a public defender, then you're just getting paid the normal thing. You're getting paid, and you only have to worry about one client. But yeah, now that
I would love it.
Right.
Yeah.
How long were you a public defender, Afi?
Oh God. Let me count. So probably about 5 years. And I did like my murders, my rapes, your burglaries, but I love my murder and rape trials. Those are the best.
Well, I cannot believe it's already been an hour.
Oh,
As I anticipated, you guys were absolutely amazing. I really appreciate you guys coming on. Please, guys, I have all their links. Afi has a YouTube and Twitter. Katie's on Twitter. And you guys know Allie and Defense Diaries. Please make sure to subscribe to all of them. And I guess you guys, and we're going to go poorly to Publicly Buzz, but do you guys have any final thoughts about this? What are your, I'll start with you, Afi. Go ahead.
I have a question, Katie. Yeah. Love you. You're so awesome. And Allie, of course, you know, I have a crush on you. But I want to say, do you know many noble prosecutors? You know, you were talking earlier and you were saying that, you know, you guys are administrators of justice, or I don't know the proper terminology, but I've dealt with a lot of, you know, God bless them. Thank you for their work. But some very interesting prosecutors, especially with the way that they time turning over exculpatory material.
We'll be here for another hour if I tell you my most recent Brady story. Let's just suffice it to say, I too have had somebody sit on exculpatory evidence for 24 months and then turn it over and be like, what? I turned it over.
The day of trial, in the middle of trial.
Oh yeah, I have a pillow under my desk, has makeup all over it, and it's labeled Katie's screaming pillow.
Yeah.
So it's so that like I won't scare the other people in the office.
I'm just
it is
saying
incredibly
the public
annoying.
is learning this. I'm just glad the public is hearing this. That we all feel this way. We all feel like, okay, these people you hold in high regard that are supposed to search for truth and, you know, be all the things that you just said, I very rarely are. I have not come across anyone who I think is of that ilk to just, if they think it's wrong. I mean, sometimes they don't have a choice. You know, it's like, you have to go forward with this. That's your job. And the higher up said, you're proceeding, you're proceeding. But there's just been so many times, including the very first time I walked into a courtroom, that a prosecutor lied to my face, that, you realize, all right, you want to say it's the defense attorneys, huh? You want to say it's the defense attorneys. We don't have the power. We're not the ones.
So if you guys see this comment here, Caleb Bumpus was on a podcast and said 14 people were in the ex parte meeting. So that's a lot of people to get a lot of testimony from if that ever happens. And then M. Shannon said,
Wait, Kayla, is that that's
the defense attorney for,
that she turned over the information. But okay, we didn't talk about whether the ex parte meeting and whether it was confidential. Because in her motion, she said that, the judge never said it was under seal. There's no requirement that this ex parte meeting be confidential. And this is what she's saying. How can it be confidential? Thanks, Rachel. If you've got 14 people there, where's the privilege?
I feel like I would have told the other side.
Yeah. And who the hell else is in this meeting?
Thank you. Who else? So there were sheriff deputies there, multiple DAs.
How many of them could there be?
With 14, I don't know. But, there's so much to talk about.
Well, and then
I was trained better than that, and I was trained in Broward. So I'll give you that we were trained. You turn over everything, and then you argue about whether it's admissible later. And I can tell you, I just got out of a trial where that was not the lesson.
So you're like, here's my file. Like I've met a few really, I think, pretty decent prosecutors who are like, here's my file, it's open. But I sometimes wonder, did they slip something out? Because I know sometimes they do. They'll slip a sheet or two out, and then they'll find it the day of trial, or they'll find it right before they close. And it's like, what do you do?
I've always been a watch my hands kind of person, and we had a way to track that you had opened the email with the Brady info. Mm-hmm. Like that somebody had opened the email and had read it. There were mandatory, like if you thought the word Brady somewhere in part of your brain that's not even conscious, you need to file a notice. And I they sat on it for 2.5 years, and I got tipped off by a third party. Let's put it that way. And then we had a big argument, and anyway, it devolved where they were like, "What? I didn't think I needed to turn it over unless there were like police reports or something."
Oh,
and
wow.
I was like, "You turn over everything," and it was very, very bad. Like, well, anybody can make an allegation. I don't need to turn it over unless there's police reports. And I was like, well, if you look, there were fucking police reports.
Wow.
So, but I could for hours. That case turned me so badly.
I don't know if you know about this, Avi. Apparently, someone in the chat, M. Shan, says talk about Yak's new motion to the Supreme Court to have about Judge Glanville. I don't know if you guys have heard about this. Sorry, I don't know. Are you guys familiar with this? Apparently, there's another motion. Maybe it was another.
No.
Writ of
I'm
mandamus.
Sure flying everywhere.
Mandamus.
What is a writ of mandamus, babe?
So writ of mandamus to mandate someone. You're trying to make someone do something. It's Latin. It's to try to get the court to do so. I haven't read it, so I don't know what they're trying to get the court to do.
Okay,
Probably
sorry.
remove the judge.
Right.
It's
mandamus to remove yourself.
Yeah, I guess that's it. So, I mean, this will be really interesting to see. It's been fascinating. And I just hope, like, I know a lot of people are very upset in the Karen Reed case because of like the state doing some shady stuff. If you're after that trial, hop on board with this one because the state in this case is doing some shady stuff and it needs attention because that's when things start happening, right? I mean,
starting with trying to hold a group of people responsible for the individual crimes of the people they associate with.
Right. And if there's
starting with that premise of the entire, as far as I'm concerned, with the entire case, although I don't.
To Afi's point, sounds like there was, this is made national news, and all of a sudden, Judge Glanville's being a little nicer after like people are seeing 25 attorneys from that. I don't know what the group was that came out and backed Brian Steele. I forgot to mention that. Like a bunch of attorneys came and they're like, we're going to stand and back him up here. And also his wife, I believe, filed one of the appeals. So like, there's a lot going on here, and you guys have, I hope, helped folks. I know you have helped folks kind of it's a lot, and you guys have been amazing. I think that's all we got here. Hopefully, we can do this again.
Before you do your outro, I just want to ask Afi to hang around so that we can chat once the outro's off.
Yeah. Do you guys have any final points? Any final things that you guys are working on? Stuff you want to talk about? I'll give you the floor. Anything you want to talk about? Or I know. Like I said, Katie, Twitter, Afi, Twitter, and YouTube. Allie, of course, Defense Diaries.
Podcast.
Go ahead. What? Podcast. Yes. Katie,
I'm good.
Oh no, I'm still just, my mind is blown about the groupthink on the prosecution team. So I it's each one of them individually has a bar card. And you don't put that on the line because everybody, like one person's jumping off the Brooklyn Bridge doesn't mean I'm going to throw my bar card off the Brooklyn Bridge. And, just because the judge says it's okay doesn't mean, like, if you've got that bzz, bzz, bzz thing in the back of your head going, I don't know if this is okay. You bring in other people, you ask questions, you say, I don't know, Judge, how do you feel about this? I'm
somebody had to ask the judge. He didn't do it sua sponte, I would assume.
Yeah, but I just like the group think there that everybody individually has their own bar card. And these are people that have hopefully been practicing for a while. And I mean, I was always trained that, you don't put your bar card on the line for any case, any trial partner, any judge. Like, I just feel like
it's hard when in the practice, so that was my first thing too. I was like, how long has Caleb Bumpus been practicing? Because when something like that happened, because Woody's attorney was, I don't know if he was out of the country or not, but I know he was on vacation. So if I were in that situation and if I were a younger attorney, but I think she's been practicing several years. So even more so, you should have somebody to call.
Right.
You have to call your gray head. You have to call a professor. You have to
phone a friend.
I would have gone to another judge. Like you build relationships in the practice. That's the only way you survive. There should be somebody you could call, a classmate, your bar study partner. Hey, this doesn't feel right. So
I got pulled into those things
Also-
even as an older prosecutor into county court
Yeah.
where they were like, I don't feel good about this. And I'd listen for a minute and go, nah, you're good.
Yeah.
Get back to work.
And by the way, Afi does an awesome job on Twitter covering this case and a lot of other cases. So please make sure you're. Go ahead, Afi. I feel like you want
Yeah,
to.
no, I'm just getting back into it. I was dealing with divorce court. It took like all of my time for like 5 months while we were shooting, and now I'm getting back into it. Oh, right on time too.
And well, you were covering Diddy, right? You were covering
Yeah. Oh man.
this case, obviously. I know you. So please make sure you're following. We've been sharing the links. They're in the description too. This is going to take you guys to Publicly Buzzed, who are live right now. Please show them the love. Go in there, like the stream. Thank you guys so much. And
Can I say one thing?
Yo, absolutely.
Oh,
Of course
sorry.
you can.
I'm so sorry to interrupt. Who has federal experience here? Oh,
I've
Allison.
done defense
Allison.
work.
Okay, so my theory, guys, putting this out there, I think Diddy has already been indicted, and I think that they're
Ooh.
holding the indictment. I'm going to talk about that.
For
But
what? I know you're going to talk about
they
that.
bugged his phone. No, I think they're getting more information. Like he's panicking. They put that information out there on CNN, and CNN is the feds. So I think he's panicking, and they want to get as much information as they can. I think everything he's doing is bugged. I think he's being surveilled. So I would put money. And I talked to a friend of mine who's oh my God, I'm brain farting. AUSA. Okay.
AUSA, yeah.
Yeah, there we go. And we kind of like talked about how they worked and how powerful they are. So I definitely believe that the indictment is done, and they're just getting some more information,
But he's already lawyered up. So then you have to have a taint team, which
Yeah,
is
but if they've got like a over here or something, that's what
well,
it sounds
not
like
if he's
that's
talking to his
what he's saying.
lawyers. Yeah.
Right. Right. Then they would have to shut it
cheating.
off when he's talking to his lawyers. But if he's scrambling and talking to his friends and saying, I would think that he'd be, if he's talked to a lawyer, he's been advised, assume your shit is bugged and don't talk to anyone except in person. But I wouldn't, I'd go with you're probably correct.
Bob says these are amazing women. I totally agree. And Spitfire Dragon says you have to have this panel back again. I would love to. Well, maybe we could do one about Diddy. We could talk about all that stuff that's been going down. Always an open invitation for these amazing guests. Please do them the good. Please follow them, comment, do all the stuff. Thank you guys so much. Have a great weekend, everybody, and we'll catch you on the next one.
Bye, guys. Thanks for coming.